We found one from 1860?
That might have been
1887.
And I know I had seen one
We said it was a reversible error if you didn't give the self-defense one, so.
well, I know I'd taken a look at one a while back. I think, but I don't have a case site for you. I think it's a question of law as to whether it applies. And so at a minimum, I think we should figure that out, I guess. But the reason we don't think it should apply is these were statements that were made by Mr. Waldman in 2020. I guess it was before Ms. Heard's counterclaim. So if he's saying that
It goes to the op-ed, I think.
Understood. So if he's saying that this lawsuit was a statement in response to the op-ed, statements that were made a year and a half later by Mr. Waldman, and it doesn't, I mean, again, Your Honor, the key words are fairly and reasonably. So obviously both sides are going to argue defamatory implication and what did the op-ed really mean, and did it say these things? But saying, even under their theory, 2 years ago I became a public figure representing domestic abuse, to say that then it's fair for Mr. Waldman a year and a half later to make public statements that Amber and her friends roughed up the place and spilled a little wine, all the things that he said in those statements, that's not fairly and reasonably. Ms. Heard responded fairly and reasonably to Mr. Depp's case through her counterclaim. The parties can speak to each other in the courtroom here, but saying that if someone makes a statement in an op-ed, that then you can go and do whatever you want for 2 years, say whatever you want. And obviously there's only 3 statements that comprise the counterclaim, but as the evidence has shown, it was part of a pattern by Mr. Waldman. It's the opposite of proportionate. It's the opposite of fair and reasonable response.
Okay.
Mr. Depp's opportunity for a fair and reasonable response, well, we don't believe it was either, but he had the opportunity to file a lawsuit in this court.
Right.
To have Mr. Waldman be his attack dog and to say anything Mr. Waldman then says as his attack dog is somehow fair and reasonable and entitled to the privilege is inappropriate. And I do think that before Your Honor gives it, we need to confirm whether it's a question of law.
Okay.
Your Honor, Mr. Roddenborn noted that this lawsuit was a response to the op-ed, but I think there could be multiple statements in response to the op-ed. So I think that's not dispositive of anything. And the statements were clearly a direct response to Ms. Heard's allegations on their face. And whether that response was fair and reasonable is a jury question.
What do you say is the matter of law? The privilege of self-defense is a matter of law?
I think it could be whether it applies.
Okay, I don't think it's a matter of law. I think it's whether or not if there is any evidence that a jury could find it being protected speech, not the weight of the evidence, but if there is any evidence. And I don't think it's my role to weigh that evidence as far as how long it was made afterwards.
I think it is, Your Honor. I mean, it can't be the case that anytime there's an alleged this is why this doesn't come up often, because this just isn't given. If it were appropriate here, every time there's a defamation case, this would be an instruction. Even the person who's the defendant in the case who said, well, all I said, I was responding to something that was said before.
So all your evidence that you say goes to the jury are just the statements? That's why this should be given? That he made the statements, that's the only evidence?
Well, I think
You gave me evidence of agency, but that's just agency. Do you have any evidence that of self-defense, that he actually said these statements because of what she said?
Well, I think there's circumstantial evidence, at least, that so it's agency. He's an attorney who was retained in connection with this litigation and the UK litigation.
That doesn't automatically give you self-defense, though, a privilege of self-defense.
And that's
you have to make them. I have to have some evidence that the statements were made in response to the direct accusations of Ms. Heard. Some evidence.
On their face, they appear to be a direct response.
Not the statements themselves, but is there any other evidence? But the statements fairly arose in response to Ms. Heard's accusation. Did anybody testify that he made these statements in response to her op-ed?
No.
Not that I'm aware of, Your Honor.
All right.
Your Honor, just one small point there. There's no requirement that it be in response to the op-ed in particular. The question for self-defense to apply is simply whether it's made in response to an allegation against Mr. Depp. And Mr. Waldman's evidence is clear, I think, that he was responding to allegations against Mr. Depp, and he believed those allegations to be false. There was extensive evidence in the record on that, in fact, I think.
That he was responding to, so if it's not the op-ed, then we're really in murky ground. If he says, well, I was responding to what she said in 2016, that's...
Well,
That's very
what Mr. Munez is saying is that you take it as a separate case. You take it as a separate case, their claim and then your counterclaim. So your counterclaim is a separate standalone case, right?
Okay.
So the standalone case doesn't, your claim doesn't deal with the op-ed. So they're saying in defense of your case, that's why this comes in.
But he couldn't have made the statements in defense of our case because these are the basis for our case. So what he had to have been, what was he responding to if it wasn't the op-ed? And if it's not the op-ed, then we're really in murky ground because there's no, plus Your Honor, couple points. To your point, there's been no testimony that he made these in self-defense to anything. Two, the defense doesn't apply. And this is, this is under the Haycock's case, 1958. It doesn't apply if we prove malice. So it has to be made in good faith and without malice. So it's coextensive. I could bring the case up if you want, Your Honor. So if the malice inquiry incorporates this, this is the, let's see, 200 Virginia 212, Haycox versus Wilcox Dunn. And it looks like on page 231, they're discussing a Massachusetts case and that says, statements made in an honest endeavor to vindicate one's character or to protect one's interests are usually regarded as qualifiedly privileged, even though they are false, if they are made in good faith and without malice. So the malice inquiry takes care of this. In addition, I don't think I need to remind the court, but for the record, Mr. Waldman was not allowed to answer any questions about this. So to say, well, he could have been making it in defense of something, they could have let him answer questions and get that evidence on the record. They can't say, well, he could have been making it in defense of something now. And when I say, just looking at your case, you're claiming these alleged defamation, the three we have allegations. Well, they're saying in response that they made them because of something she said that maybe is not the op-ed. But then there's no evidence of what that is. She was sued. She said 2016 when she made her and 2018 she has the op-ed that have a couple words that they're trying to turn into what we've just seen for the last 6 weeks, and then she responded to the lawsuit. Okay. So it can't be the case that by trying to defend yourself in a lawsuit that was brought against you, if it's not the op-ed, then it's got to be her statements in the lawsuit, that somehow trying to defend yourself through judicially immune statements in a lawsuit entitles someone else to go out and say whatever they want and then try to veil themselves in the privilege.
Counsel for Ms. Heard made a point of making clear that there was extensive allegations about Mr. Depp circulating. They repeatedly brought up the UK action, which was in fact the context in which I believe these statements were made based on the date. It was very close in time to the UK action. They brought up the Dan Wooten article. These allegations date back to 2016. These allegations are out there, and there's evidence, from which the jury could find that Mr. Waldman was acting in defense of Mr. Depp.
Acting in defense against Ms. Heard's accusations. So what are Ms. Heard's accusations that would be defense, that are in evidence?
Your Honor, there has been extensive evidence of the accusations against Mr. Depp going back to 2016. For example, the Dan Wooten article that they raised in evidence prior to the op-ed, which included the word wife beater, and it was essentially,
But it has to be.
That's not Ms. Heard's statements.
Ms. Heard's statements. Right.
I don't believe that's correct, Your Honor. It doesn't have to be
Against Ms. Heard's accusations, it is correct.
That would be crazy, Your Honor, if they get a jury instruction because he was responding.
I understand that.
Again, the number of allegations made by Ms. Heard, it's been very well documented in this case. You have the op-ed, and it doesn't have to be just, it doesn't have to be any one particular allegation, but you have the op-ed, you have the People magazine article, you have the republication of her statements through the wife beater and the Dan Mooten article, you have the fact that she was giving testimony in the UK action about these issues.
Well, then would you agree that actual malice, you don't get the self-defense if there's actual malice in his statements? If the jury finds actual malice, then you don't get.
If the jury finds actual malice,
Then it's not protected
that may
speech.
obviate the privilege, but that doesn't mean that the privilege is not applicable or a valid.
But the only way they can find in this case is if there is actual malice. This goes back to their defense, slap defense as well. The only way they find defamatory statements in this case is if there's actual malice. And it's unique to this case, I understand that. But so if they find actual malice in defamatory statements, you don't have protected speech privilege.
And if there's no actual malice, they win.
Yes,
So-
correct. The same with this,
It's-
that's why we're
right.
not giving a jury instruction on the slap defense,
Right.
because there's no basis for it.
I mean, if the instruction is not being given on the understanding that it's essentially moot,
Which I agree, I think was what happened with the slap defense as well. We found out, after we went down that legal road, we found out that was moot as well. Okay, so you want me to deny it or withdraw it? I'll do either one.
if you don't mind denying, Your Honor.
Okay, that's fine. I'll deny. That's instruction 28 and 29. Okay, put that in the deny stack. All right, next one I have is the republication one. Okay. So I see both of them dueling paragraphs for the
Your Honor, if you'd like.
republication. Yes, sir. And I understand last time we spoke that you must determine whether any content that was added constitutes a republication. And you just would rather have just the 3 sentences as yours for republication. Is that correct?
Correct, Your Honor.
That didn't,
No,
well,
no, I
you
think
must
it's
find
the
that
flip.
she read, or you want to add that into it? I'm not sure. I'm just not sure how I'm reading it.
I think, and I don't mean to put words in their mouth, I think we want the whole thing at the top.
Right?
And they just want the one sentence at the bottom.
That's
Okay,
correct.
that's correct.
And Your Honor, we talk about not going backwards. We went
No,
over
I
this on
understand.
Friday. Your Honor said that on page 92 of the transcript, I don't have a problem with the republished jury instruction. I just think it has to be accurate with adding the language. And
Right.
that language was on page 89. You said, but you also have to say, but adding content to it may establish republication. So that's what we did in the sentence that starts with merely linking.
Right.
It did say merely linking to an article does not amount to republication, period. And then we added directly from the transcript, but adding content to it may establish republication. So now they're going backwards. They just want you to strike the whole thing except in the first sentence. And that's different from Your Honor's ruling on Friday and also doesn't fully capture.
No, it
the
doesn't
republication
capture the whole
doctrine.
legal
Well,
argument.
And if I may just make our argument for the record here,
I
Your
agree with what
Honor.
you did on Friday, but if you want to do it again, that's fine.
Okay, just very quickly. So I think the issue with republication is whether it reaches a new audience, which is what we
And that's there.
propose. Right, it's included in their instruction, and that is basically the full extent of our proposed instruction, and we believe it should be limited to that. Lakova is a case that they've repeatedly cited in support of this republication issue, and that's a case where there was a defamatory New York Times article that was hyperlinked in a more recent New York Times article, and the court said that that's not directed at a new audience. It's the same party tweeting to the same audience, so there's no republication. And that's not the case here, where Ms. Heard has retweeted a Washington Post article. So that, Ms. Heard's audience on Twitter is different than the Washington Post. And so
But if she just retweeted a hyperlink, that's different. But in this context, and that's why I took the motion to it, and that's why I'm putting it in the jury instruction, because it is accurate that a hyperlink alone is not enough to reach a new audience. What I think would also add to it, though, is after you must determine whether any content that was added constitutes republication. And let's see, I would say then you must determine whether any added content republish the op-ed to a new audience. I could say it that way. Or I could say, but adding content to a linked article may constitute republication. You must determine whether any added content was intended to reach a new audience. If you find it was intended to reach a new audience, it constitutes a republication. I could say it in that term. Add that to the end of that paragraph.
I think that's fine if that's the court's inclination.
Do you have any objection to that?
I'm thinking, sorry, I'm
Okay.
slow on
Repeat it
the.
one more time.
Yeah, that,
Sure, okay. Let's see. All right, let me see if I can incorporate it into it. Okay, so merely linking to an article does not amount to republication, but adding content to a linked article may constitute republication. You must determine whether any added content was intended to reach a new audience. If you find it was intended to reach a new audience, it constitutes a republication.
I think we would prefer just to say just that first sentence, merely linking to an article does not amount to republication, but adding content to a linked article may establish republication, period.
Well, that's what you already had. This is
No, because we had you must determine whether any added content that was added constitutes a republication. I think it'd be better to just delete the last two sentences than to add the sentence at the end.
Your Honor, I just want to note, I don't think that adding content is a requirement for republication. I mean, we've found a number of cases that when somebody repeats a defamatory statement, that they're as liable as the original defamer.
We're not going back. We're not going backwards. So either it's his language or my language. What do you want?
I prefer the court's language.
All right, I'm going to put my court's language. Okay.
Do you want us to do the revisions? Because if you do, we may have to just get one more time from you.
Okay.
We're happy to, or
Sammy, can you do it? You gave him to
We did.
in Word format?
we did.
All right, can you do that? Here.
The only other thing I would note is I think the word retransmitted in the second line is misspelled. So
In the second line? Okay, all right, we'll take care of that. But adding content, just do it. Adding content, yeah, it's like this one right here.
Okay.
And then just get rid of all of this and add this instead. We'll take a look, okay? All right, and we'll clean it up. We just take out the box. Okay, we'll get that done. All right, takes care of that one. Next one is, I think, instruction FF. Defamatory meaning, consider the publication as a whole. And we have dueling answers here. And the defendant just has op-ed in it. The plaintiff just has it as plain, which, I mean, it does say that it means you may not seize any word, phrase, or image. So it would appear that, so it could apply to both of them in that context.
the problem, Your Honor, is that we believe that because the counterclaim statements that the jury will be presented with are redacted, so the statements are in isolation, that there's a risk that as they're phrasing it, the jury may read the phrase, you must read the statements in context as a whole, to say, well, we can't do that, so therefore there's no liability. We think because it's impossible to read those statements in the context of the whole piece. And so that's number one. Number two, the op-ed was all Amber statements. So the whole thing was her words. The counterclaim statements were Mr. Waldman's quotes in another article that we don't believe, well, that's not in evidence. So there's no point arguing about that other than you just have these one or two sentences from Mr. Waldman. So we believe that the jury's going to be confused if we give their instruction and say, we cannot read it as a whole. So therefore we can't, follow the jury instruction.
Okay, I can see your point with that. Yes, sir.
I don't think there's anything there's a lot of instructions here. I don't think there's anything that would indicate they can't find a liability if they're not able to take statements in their proper context, in the context of the entire article. Just thought it would be more appropriately phrased to be mutual, as opposed to obviously applying only to one party.
Well, because yours says you must read the statements, which is true, but you also can take the content in the context as a whole, but you can take the context of the op-ed as a whole, which is accurate. What I could do, if you want, I could keep the op-ed up top for their claim, and then for your claim, we can, in determining whether any of the statements attributed to Mr. Waldman are false, and and defamatory, you must read the statements. I could keep that in there as the second paragraph. That way they can't just pull out, because it's accurate law also, that they just can't pull out the word hoax and say, okay, this whole statement.
Agreed.
Okay?
That's fine. Thanks.
Is that okay?
That's fine in concept. I guess I would ask if Your Honor does that to add a clause saying disregarding any redactions on.
Well, it says the statements themselves, statements, and there's, you must read the statements in context as a whole.
Right. So I think, I mean, could we say in determining whether any of Mr. Waldman's statements or whatever are false and defamatory, you must read the text of those statements as a whole? The text of those statements in context as a whole or something.
Well, it's kind of, you must read the statement in
You must-
context as a whole. I
You
think
must read,
that's-
can we say you must read those statements in context?
You
as a
must
whole?
read those.
Because I just don't want
statements in
them to think
context.
that it's impossible for them to.
Any problem with just putting those instead of the?
I don't think we have a problem with that,
Okay,
Your Honor.
in determining whether any of the statements attributed to Mr. Waldman are false and defamatory, you must read those statements in context as a whole. This means you may not seize on any one word, phrase, or image, or consider only one particular statement, phrase, or passage in isolation. Does that sound correct?
Yes.
All right, we'll add that as a second paragraph. Keep Sammy busy. All right. Takes care of that. All right, the next one I have is the objections and assertions of privilege.
Which? 32.
Oh, I'm sorry, it's
Sorry.
Depp 32. It's a new instruction.
Yeah, right.
Yeah,
This is
you
the
have
one at
the
the end. This is the new one.
Do you have the
Um,
objection?
We do. Yeah.
Okay.
The objection, Your Honor, is that the objections made by counsel during the course of trial, we have no problem with something on that. But instructions, what they're trying to do is to direct the jury what inference to draw from Mr. Waldman's instructions not to answer.
Well,
And
the only legal inference they can draw, they can't draw any inferences from that.
exactly, and that's my point.
Well, and that's what this says. You may not draw any inferences from the fact that objection was made.
Yeah, but saying sometimes attorneys stated objections during the course of this trial and instructed a witness,
Right.
and instructed a witness not to answer a question. Objections and instructions to witnesses are not evidence, and you may not consider them in reaching your verdict, nor are you to draw any. So why do they need to be told this? I mean, I think this risks confusing the jury.
Because to be fair, in the depositions, you wanted to keep in all those objections. When we usually would take them out, but you wanted to keep them in. So I want to make sure the jury doesn't have any improper inferences from leaving those objections in. You wanted to leave them in because show that, hey, I asked the questions, they weren't answered, fine. But you can't infer from that, oh, well, they're hiding something then, or it's attorney-client.
Understood. I mean, just like you can't infer when someone takes the fifth in a criminal case. I get that.
Right, which
but-
I would give an instruction for.
Of course, I know, I understand that, but I think that the jury is entitled to draw their own conclusions and not inferences. They're not entitled to infer anything from that. But I just think that this risks confusing the jury and getting the jury to think, if they stand up in closing and say they haven't presented any evidence that Mr. Waldman was doing this, then that's using this instruction as a sword. If they get up there and say they haven't, do you understand what I'm saying? They haven't proven that Mr. Waldman was acting as his attorney. They haven't proven that Mr. Waldman was authorized to make the statements. Then they rely on this to hide behind that. And we're not allowed, and I'm not saying that we will, but I'm not going to say, you heard him instruct him not to answer, and you should infer that he was acting as his agent. I know I'm not going to say that, but if they're going to argue in closing the converse of that, then that's prejudicial, and makes this inappropriate.
All right, yes, sir, Mr.
Your
Reyes.
Honor, this is just an accurate statement of law. They chose to play about 30 minutes of Mr. Waldman being instructed not to answer. Without this instruction, that's prejudicial.
All right.
And it would also be prejudicial if they're allowed in closing to say that we haven't presented evidence of anything about the parameters of Mr. Waldman and Depp's relationship.
That doesn't follow from this instruction.
does.
This instruction is simply saying that the jury is not to draw any inferences from the objections and instructions inserted by counsel. They can consider the evidence. They can consider whether evidence was presented or not. The instructions and objections are irrelevant to that question.
No.
All right, I understand your objections, but it is an accurate phrasing of the law. And I want to make sure that the inferences aren't taken against an attorney-client privilege.
Okay. Can you deny it over our objection?
You got it. I mean, no, I can grant it over your objection.
Sorry.
Good, Freudian
I
slip.
meant grants. Yeah, sorry.
Okay.
Can we get some direction for the arguments that they're allowed to make on closing on that, Your Honor? Because I don't think that's appropriate for them to point to a lack of evidence when they didn't allow Mr. Waldman to testify.
Pointing out that instructions are not evidence is not the same. There's no connection here between these issues, Your Honor.
No, I'm not going to do that. So we're going to do Depp 32. I just need to clean up the top part of it. Okay. All right. Over objection. Be offered. All right, then I have instruction JJ, which is the model.
Right.
So why would I not give the model?
We believe you should. I think the only looks like the only substantial difference is that rather than saying as it's written, it says clear and convincing evidence that Mr. Waldman's statements. It's confusing and misleading to say that if you found by clear and convincing evidence that Mr. Waldman's statements were made by Mr. Depp, we already have a principal agent instruction.
Right, if they find principal or agent, I mean, that would be the only basis for it.
Well, first of all, Your Honor, if liability is entirely vicarious, which I think is the position of the counterclaim plaintiff in this case, I don't think there's any evidence of direct liability. If liability is entirely vicarious, then I don't think there's a basis for a punitive damages instruction at all against Mr. Depp, because vicarious liability generally doesn't result in punitive damages as to the principal. Punitive damages are only applied where the person against which punitive damages are being assessed actually engaged in conduct that it was wrongful, and that's not the way they've pled and sought to prove their case. I think that's the first.
So they're correct, okay? They're saying you're not entitled to a punitive damages instruction.
Well, I disagree with that, and there's no case law that they've cited in here on that, and I think that's going backwards. That's an argument that we are, and I just think that Mr. Waldman's statements were made by Mr. Depp. I mean, I'd be okay with something that said that Mr. Waldman, while acting as an agent for Mr. Depp, made statements with knowledge. I'd be okay with that.
Is that okay?
I think we would maintain our objection on that. On the basis previously asserted, Your Honor, and then what's the other? I'm sorry, could I have counsel's language again one more time?
Sure.
Yeah, if you have found by clear and convincing evidence that Mr. Waldman, while acting as an agent for Mr. Depp, made the statements with knowledge that they were false or so recklessly, I think it's so reckless. There's a typo there, sorry. We'd be okay with that.
Yeah, I mean, we do maintain the same objection, Your Honor, the principal liability, and we do have case law for that proposition.
I'll overrule that objection. We'll go ahead and, can you type that up real quick for me?
Sure.
And get that to me. If you email it to Sammy, we can print it out.
Yep.
Okay, you're in charge of that one. Okay. All right. That's fine. I think that was it, correct, as far as?
I think it was, other than the verdict form.
Perfect. Let's go to the verdict form. Do you have the other ones for you, Sammy?
Typing it out.
If you can print those out.
Yeah.
All right, let me get the verdict form. All right, I think with the verdict form, it was just the first page. Am I correct with that?
In the punitive damages.
And the punitive damage, you didn't have a response, right? Do we have?
I think there was a comment in what we got from them that we changed.
Okay. All right, well, in the, here. Oh, thank you. All right, I think it was in 1A, the statement was about Mr. Depp. I think the plaintiff wanted that out because we already have, the statement has a defamatory implication about Mr. Depp, and the defamatory implication was designed and intended by Ms. Hurd, which I think is.
If you look at the, I think it should track the finding instruction, which is jury instruction C on
Okay.
page 4 of the jury instructions, and that's what the verdict form does.
Okay, let me take a look. And that was C, okay.
Yeah.
Okay,
So the way it's been written tracks the
all
finding
right,
instruction.
tracks the finding instruction.
Yeah, we don't have a strong objection here, Your Honor.
Okay.
I thought it was maybe cumulative, but
It does match the finding instruction, which would be clear to the jury, so we'll keep that in.
that's fine.
And then the punitive,
And so
So
that
on
would
the
carry
last-
through to all of the,
oh, you withdrew all those?
We'll withdraw that, Your Honor. Their proposed language is
All
fine.
right, so the verdict forms as written are the verdict forms good to go, correct?
well, are you,
What was-
I'm sorry, did they withdraw the punitive damages? Okay.
So we're good with the verdict forms. What I have is the verdict forms, correct?
Your Honor, I think yes, but I do just want to make sure, and I understand we don't go back, but I just want to make sure that for the record, we do maintain that the verdict form should state that the defamatory implication was false and not that the statement was false, because under the Pendleton case, that can, a facially true statement can still have a false defamatory implication.
And I think we had that on the record on Friday, but thanks for putting it again, it's fine. All right, so verdict forms are good. So we'll keep the verdict forms. Did you print out the other? No, you can print it out. That's how, yeah. So which ones are we missing then? We're missing which jury instructions? You're working on 2 of them, right?
32. I have 32 in FF right now.
32 and FF, and you have 1 jury instruction for me, right?
Yes,
All
they're
right.
editing it right now. It's JJ.
Okay, JJ is coming in, and did you do the other one yet, or no? Here, I got that one. Here, could you guys do, Michelle, or could you, on Depp 32, could you take off disputed and send that to us too?
Yes.
Thank you. And that would just leave us, we'll get those 2 printed out, and then I'll tell you the order that I'm going to do them. While I'm doing that, I do have the laptop, if both sides would like to look at the jury evidence on these. We'll stay up here at the bench, but all we did was we put 2 files on here. There's no password for it. As soon as you open up, it doesn't have any internet, and there's just 2 files. One's plaintiff, one's defendant. They just click on those 2, and then they can watch all the audio and the video, okay? So if you want to take a look and make sure it's been downloaded to everything that we put on our website, which is all the evidence. We didn't receive any new evidence today for audio or video files, so that it's everything on there. But if you want to take a look and make sure that everything is there, you can do that. Also, all the tangible exhibits Jamie will have, except we need to get those other ones. So you have them? Perfect.
Yes, if I may approach, I have
Okay, sure.
1301.
Okay.
And then, Your Honor, I just would like some clarification.
Sure.
I understand that Defendant's Exhibit 712 and Defendant's Exhibit 713 were initially moved into evidence in redacted format.
Correct.
Today, we offered them and put them in an unredacted form, so that's the
712A and 7.
and then
713A.
713A.
Yeah.
I believe Your Honor should already have those in unredacted form. I believe that's how they were provided to you
Oh, they're in
all
our binders
by-
down here?
I believe so. I will. Yes, so I believe those, you should actually have those in unredacted form
All right.
from defendants.
All right. We have a
Oh.
few binders down here. Hold on.
Yes, I think they would be in the binders, that's correct.
7:12 and 7:13. All right, we'll take a look at those. Yes.
So I can give you a copy. I was gonna make a proper for the ones that.
Do you want to go ahead and make a proffer now?
Yeah, but it included 7:12 and 7:13, so I can give you copies of that.
Oh, you can? Well, that would make Jamie happy since she's down here digging through binders.
Right, so I can give you copies of that right now.
Okay, perfect. All right, now we have those in evidence. Okay, so are we missing any more from over here? Or did you find out about the one that you thought was in evidence?
So, Your Honor, defendant, I believe, it's Plaintiff's Exhibit 120D. I believe actually Sammy and I had a number of back and forths about this exhibit. I believe that Defendant's Counsel provided a redacted version of that exhibit to the court, but based off of our reading of the transcript, that exhibit was not actually offered into evidence.
Okay, so it's not in evidence
It's
then.
not in evidence, Your Honor. I thought, and I believe I emailed it to Sammy, last week.
You gotta take disputed off.
If you don't have it, I'm happy to bring it tomorrow, but it's not in evidence, so we can go back to the.
Okay, all right, so I just want to make sure, because it was checked off on somebody's list that it was in evidence, and I just want to make sure. I don't know, but it's not. We're good.
And
We're
then I heard the exhibits 711A and B. I'm not sure.
No, I think
Is that
7:11 was
an
wrong.
error?
It was 7:12 and 7:13. So we're good.
All right.
So Jamie, are we missing anything else? Sammy, did you print out the ones that they sent you to? The email, did you email Sammy the?
He's just double checking right now.
Oh, okay. We'll get that in a second. Let me just put these in the order. All right. Get that one without dispute on it. Okay, sure. Republication.
This last paragraph. To go across town where you get.
It was in the one that I gave you. Let me see. Yeah, that stays in. Yeah, that stays in. You want to go and print that out? Yeah. All right. Just print out 2 copies so we can share them. The one that Sammy printed off on republication, I'm just going to give you copies to make sure they're right, okay?
Yes, and you should receive in your email soon, FF, JJ, and 32.
Okay. So if you print those out too, Sammy? Let's print those out. So you're sending FF also?
Mhm.
Okay. Did you take the disputed off the top? Thank you. All right, let me just get those printed. Could you print me out another one of AA? There's a mark on this one. Or at least email that one to Sammy. Something in the paper and it just doesn't look right. Got it? Printing?
I'm not.
Huh?
I'm not.
I'm sorry.
I'm not gonna. This one's.
Can you send them to Jamie so she can print them out?
Yeah, she wanted to.
Your Honor, will we be getting just a paper printout or an electronic copy from the court?
All I have is a paper print.
Okay, so we can
So
scan it.
You can
and-
scan
okay,
it and
that's
do,
fine.
if you want to do electronic, that's
Um,
fine.
And will these be posted on the,
Not until after I get
not till
them.
after? Okay, wasn't sure. And then they're read before closing.
They're read
so-
before closing. All right. So we have.
Thank you. Okay, so I guess we just replace.
Thank you.
Oh, okay.
If you want to take a look at that instruction and make sure it looks okay before I add it to the stack. Do you have the actual malice one? Was that sent to you? Michelle, you sent the actual malice one?
Yes.
Okay. Oh, never mind. Jamie already gave it. Sorry, Jamie.
And Your Honor, was it,
Is there?
no, I think it's fine. Does the court want to leave the, herd C, Depp 7
No.
sort of things in there? Because otherwise we could,
Oh, no, well, yeah, the numbers at top can stay. I just
Okay.
don't want to say disputed.
No, I don't think any of them say disputed.
Okay. No, the numbers, I tell the jurors to disregard the numbers and the heading. That's better for the record if we keep it that way. Okay, so are you still reading the publication? Okay.
Your Honor, can we get, sorry to bother Sammy, could we get one more printout of the actual malice instruction?
Sure.
Thank you.
Jamie, can we get another actual malice?
AA. So these are only copies.
All right, any objection to the republication then? As typed?
No, Your Honor.
Okay. Put that in there as well.
Hold on.
Is there a typo?
Nope. It's okay.
It's okay?
Yep.
All right.
Your
Okay.
Honor, I just have a very quick question regarding closing arguments, if
sure.
we may. Does the court have any objection to us playing very small clips of,
As long as they're in evidence, you can play anything, show any picture.
well, that's my question. So
Okay.
obviously depositions were by video, many witnesses, especially from Ms. Heard. Do you have any objection to us playing video depositions, portions
If
of?
it's not in evidence, it doesn't get.
No, of course, just what's in evidence.
There's no video depositions in evidence.
Oh, I see what you mean. Okay, so,
The only thing that can be played to them is what is in evidence.
but their testimony, it's witness testimony.
Well, yeah, but depositions are witness testimony that you have during trial. That doesn't go back to the jury as evidence. And video depositions are the same. That would give more weight to video depositions than witness
Well, so
testimony.
my question is a follow-up question to that. Obviously, this trial was televised, so there are videos of witnesses testifying.
No,
so-
none of that comes in.
Okay,
The four walls of this courtroom is what the jury decides this case in,
okay.
period.
And just so we don't have a problem tomorrow, also, we can't put in front of the jury written deposition or
That's
trial
correct.
testimony.
That's correct.
Understood.
Only things that are in evidence. But
Understood,
you
Your
can
Honor.
show pictures in evidence, you can show video that's in evidence.
Or audio that's in
Or
evidence?
audio that's in evidence,
Okay.
all that's fair game.
Okay.
You just-
No display of written transcripts either.
No written transcripts, just only items in evidence. And,
No, I'm on the same page.
okay, all right, so I'll make sure.
Thank you, Your Honor,
And
for
you
that
have-
clarification.
And you have 2 hours, right?
Right.
2 hours each, and two people over here and 2 people over there, is that what's gonna happen?
Yes, Your Honor, we're going to split our closing, and then only one of us will do the rebuttal.
Okay, and that has to just be on the rebuttal case, correct?
Right. Right,
We have that down, right? We've gone
Understood.
through that a few times.
Understood.
Mr. Chu, do you have something on that?
Yes, I just wanted to make sure we were all on the same page. So plaintiff goes first,
Correct,
then the defendant,
Does.
counterclaim plaintiff.
right. They do
Then-
their defense to your claim, and also they do their offense to their claim.
And then plaintiff.
Plaintiff gets to do their defense to their
And they
claim and
respond
rebuttal.
only with respect to the
Rebuttal,
to the
to their
rebuttal.
rebuttal to their counterclaim
counterclaim.
only.
And so it goes 1-2, 1-2, and plaintiff gets 2 hours, they get 2 hours.
Total.
Is it fine if it's not exactly 1 hour
Oh,
for each?
that doesn't matter
That's
to
up to
me.
us.
No,
Okay,
as
thank
long
you,
as your
Ron.
time is just 2 hours, it doesn't matter how much anybody does.
Thank you, Ron.
Okay?
If you wanted to shorten that to about 15 minutes apiece.
I would want to short it to 2 minutes, but that's not my take. I
We
gave you
got
2
pretty-
hours. I thought
we
that was
got
good.
pretty efficient at the end of this
Well,
case.
it's amazing how that happens,
Yeah.
It's kind of like the physics, you make a circle and the people will fill that circle. Well, that's what happens. I made a circle. Okay, so let's go ahead, let me just go ahead and read into the record the order that I'm going to give the jury instructions. I'll also read in the record the instructions that were denied. And I will read the instructions that were withdrawn, just so we have a complete record, okay? All right, here we go. All right, so for the jury instructions, I'll read them in the following order. Number heard I, number 3, number 10, 1, B as in boy, C as in Charlie, D as in Delta, E as in Echo, F, G, H, 12, 13, Y, FF, AA, BB, DD, that's David, DD, TT, CCC, 20, Z as in zebra, T, U, V as in Victor, K, L, 5, 6, 7, 32, 8, 9, 16, I, 30, KK, and JJ. All right, those are the ones that will be read to the jury in that order. Okay. The ones that were denied was instruction 22, 23, 24, CC, NN, both as in Nancy, OO, PP, RR, SS, S as in Sam, SS, 28 and 29 were the ones that were denied. The ones that were withdrawn for the record was instruction A, 2, 4, 11, 14, 15, 17, 19, 21, 25, 26, 27, X as an X-ray, 31, W, EE, GG, QQ, DDD, Q, 18, J, M, N, O, P, R, S, HH, LL, UU, VV, WW, XX, YY, ZZ, AAA, and BBB. All right. So I will get you copies now. I'll get you hand copies of the jury instructions I'm going to read in that order, so you'll have copies when you leave here, okay? And I'll give you copies of the verdict form as well. And you can have those while you prepare for your closing arguments. Other than that, if you could come up to see Jamie after I leave the bench, just to make sure you go through the exhibits and everybody okays the exhibits, so we don't have to do that tomorrow. And also if you can have a look at the laptop with Sammy, just to make sure all your exhibits are there that are going to go back to the jury, okay?
Your Honor, one quick question
Okay.
about closing to make sure
Sure.
we don't have any issues tomorrow. Understand the jury only sees evidence
Yes.
that they've seen in the trial. If that evidence is displayed through like a PowerPoint or whatever, are headings allowed, or do you not want the jury to see any written text or anything other than just evidence?
I mean, I've seen PowerPoints in cases before in med mals where they have their other items up there, but I think in this particular case, I'd rather just have no writing and just have your arguments orally.
That's fine. I just wanted to, make
Okay.
sure that there wasn't
Just try to keep it clean.
or paraphrasing of witnesses or anything like that.
Okay,
It's just,
that sounds fine with everybody. Does anybody?
that's fine with me.
That's a good question, though. Are you going to have a PowerPoint?
Probably with evidence.
Okay.
You know.
Did you want me to have the big screen up as well? For the
I think
PowerPoint?
so. Yeah, I think that would be great.
Thank you,
Okay.
Your Honor. Yes.
Okay,
Thank
good.
you.
We'll do that as well.
And starts at 9.
Starts at 9. Closings start at 9.
So, Your Honor, Mr. Nadelhaft has a proffer still on some
Oh,
things.
yes,
Do
okay.
you want to do that now before we?
Sure.
As does
Yeah,
Ms.
everybody
Myers.
wants to hear your
I have
preference.
a-
As does Ms. Myers at the end of Mr. Nadelhoff's.
Yeah, okay. All right, they have one too. So that's all right. Go ahead.
Yeah. This will
If
be
you could just get to
shorter.
the microphone
Yeah.
so I can hear you better. Or the court reporter can hear you better.
This will be shorter than the other day.
Oh, good.
Okay, this is for metadata. On May 16th and May 17th, 2022, the defendant attempted to introduce into evidence photographs from May 21st, 2016 that included metadata on the photographs. Ms. Hurd testified that the metadata was included on the photos by pressing a button on her phone. The metadata demonstrated the pictures were taken on May 21st, 2016, along with the times they were taken. The exhibits were defendant's exhibits 700 through 726 and are exhibits A through AA of the proffer. Tabs N and O of the proffer are now blank as defendants 712 and 713 were admitted with the metadata on May 26, 2022. Mr. Depp objected to the metadata on the document, stating that the metadata was hearsay and there was no foundation for the hearsay. The court sustained the objection on the ground that the metadata was hearsay and that there was no foundation, and admitted the exhibits, but redacted the metadata. And then separately, we have a proffer for Stephen Duders. On May 20th, 2022, Ms. Hurd moved to designate certain portions of the deposition testimony for trial of Stephen Duders, who was Mr. Depp's personal assistant. Mr. Duders testified that he was on the Boston flight and sat in a seat facing Ms. Hurd and Mr. Depp. He further testified that the day after the flight, Mr. Depp told him he wanted to, quote, smooth whatever issue, end quote, existed with Ms. Hurd. Mr. Depp asked Mr. Duders to, quote, write a text, end quote, to Ms. Hurd and to say, quote, whatever she needs to hear, end quote. Mr. Duders then sent a text message to Ms. Hurd about Mr. Depp stating, quote, when I told him he kicked you, he cried, end quote. The testimony is contained in Exhibit A, Mr. Duders' deposition. Ms. Hurd moved to admit the text message into evidence, arguing it was not hearsay under Rule 2:803, which provides for the admission of statements of a party opponent and his agents. Ms. Hurd argued Mr. Duders was acting as Mr. Depp's agent when he sent the text, and the text message was therefore not hearsay. The text message is Exhibit B to the proffer. Mr. Depp objected to the text message as hearsay, arguing that although Mr. Duders was Mr. Depp's employee, sending text messages to Ms. Hurd was not within the scope of the employment. The court denied the motion to admit the text message in testimony, finding that Mr. Duders was not acting as Mr. Depp's agent when he sent the text message. And I have copies to provide.
All right, fine. We can add it to
The
the
list,
list. We have a box for you. All right, we will
Where's this?
add that.
Oh, sorry, Eric.
I think he has more.
And this is the other one.
All right, we'll make them part of the record. Thank you, sir.
Thank
All
you.
right, yes, Ms. Myers?
Thank you, Your Honor. On May 25th, 2022, plaintiff intended to call Dr. Kim Collins as an expert witness in forensics pathology. Defendants objected on the basis that Dr. Collins had not been designated as a defensive witness and was designated only to rebut Dr. Jordan, which was defendant's forensic pathologist who had not been put up at this trial. Dr. Collins intended to testify as to whether Ms. Hurd's descriptions of violence and injuries allegedly sustained by Mr. Depp were consistent with the photographic evidence at issue in this trial. She also, for incidents where there was no photographic evidence, she would have testified as to what injuries she would have expected to see based off of the violence that Ms. Hurd testified to. And finally, she would have testified as to her opinion as to the cause, or as to Mr. Depp's finger injury and what she observed consistent, which was similar to what Dr. Gilbert testified to today.
All right, thank you. Any other proffers? Okay. All right, so just don't leave here until you check the laptop and you check all your evidence and make sure we get your checkbox on that and everybody's happy with it, okay? Anything else for the court?
Thank you.
Really?
No, thank you.
Thank you very much.
Thank you. Okay,
Thank you, Your Honor.
we'll see you in the morning.
All right.
everyone, I'm Michelle Yu, and welcome to the third hour of For the Record here on Law and Crime. Thanks so much for joining us. Earlier, Judge Ascarati dismissed the jury for the rest of the day in the Johnny Depp versus Amber Heard defamation trial. The jury will return tomorrow at 9 a.m. Eastern Time for closing arguments. Before we break down that star-studded case, I want to remind you of the other case we are covering down in Florida. Today marks day 7 in the retrial of defendant Catherine Magbanua. The state rested yesterday, so today the defense began to present evidence to the jury to prove she is not guilty of a first-degree murder, conspiracy, and solicitation to commit murder of FSU law professor Dan Markel back in 2014. If you want to check this trial out, you can also watch it on our YouTube channel. And now, though, circling back to Fairfax, Virginia, both sides have rested in day 23 of the civil defamation trial of Johnny Depp versus Amber Heard. All the evidence has now been presented to the jury, and the parties will return to address the jury one last time in their closing arguments tomorrow. Judge Ascarati has allowed 2 hours for each side, and after she reads the jury their final instructions, the case will then be handed over to them to deliberate. Now, Law and Crime is all over this case, as you know, in Fairfax, Virginia, so tune in tomorrow and we'll keep you up to speed with any movement in that courtroom while we near the end of this star-studded trial and begin verdict watch. Now, since court is in recess, let's recap some of the rebuttal testimony of the forensic psychologists called in this trial, each presenting very different perspectives about Heard and PTSD. Let's take a look at Dr. Shannon Curry's testimony first. She was hired by Depp's team.
All right. Dr. Hughes says that Ms. Heard has PTSD. Do you agree?
I do not.
Why not?
The results of my multi-method comprehensive evaluation based on carefully selected, researched, relevant test instruments, based on comparing those instruments to Ms. Heard's self-report, observing Ms. Heard's behavior over 12 direct hours of assessment, reviewing copious notes from prior therapists who indicated symptoms in their notes, reviewing the notes of Nurse Filati, previously Nurse Borum, who spent, I believe at one point, almost 2 months with Ms. Heard daily, reviewing the notes of her treating providers, all of the legal documents and discovery. There was no evidence of PTSD.
How is evidence of PTSD generally exhibited?
So really the bottom line in a forensic psychological evaluation is a change in functioning. That's what we're looking for. Again, I said, we don't have a crystal ball. We're not wizards. We can't get into somebody's head. What we're looking for were there identifiable changes in the way the person engaged in their world. Were they able to keep a job? PTSD is an extremely disabling diagnosis. When a person has true PTSD, it is difficult for them to work. You'll see unemployment, job loss. It causes extreme levels of distress and impairment. There's divorce, there's isolation and estrangement from children, from family members, extreme alcohol abuse, often a string of sudden DUIs when the person never had any before. They become homebound, they can't go to the store. They're certainly not going to events. They're not having success in their film career, usually. They're not exercising every day, pursuing their hobbies, being avid readers, obtaining level 3 sommelier training, having dinner parties with friends, speaking to public groups. Those are just indications of very high functioning. And when you're looking for a decrease in functioning over time, that is inconsistent with that decrease.
All right, with that in mind now, let's compare Dr. Curry's testimony against what Dr. Dawn Hughes said when she returned to the stand to testify in Amber Heard's rebuttal case earlier this morning.
Dr. Hughes, Dr. Curry also testified that a victim of PTSD has to effectively be prone and unable to function at all. Would you agree with that?
Objection, misstates the evidence.
She said they couldn't hike, they couldn't move, they couldn't function in any shape, way, shape, or
Overruled
form.
objection.
Thank you.
No, that is not correct. That is often actually a myth and misconception about individuals who were struggling with PTSD or trauma-based disorders. And I'm often called to answer that and speak to that. People who are struggling with trauma and PTSD are very strong, courageous, resilient people, even though that they're struggling. They get up, they have to go to work and drop their kid off at school and go to the market, even though they're struggling with these symptoms. So I often talk about it as this sort of walking around with a 50-pound bag of flour on their backs, just sort of trying to get through the day, where sometimes that button's going to press play and the trauma is going to start activating in their head, and then they're going to be having to think about it and have startle and have physiological reactions until they can find a way to hit that pause and shut it off again. So they still have, impairments in other ways, but they go about their lives. They're not, totally debilitated. If you have someone in that high range, the highest score is an 80 on the CAPS, Ms. Heard had a 28. If you have someone in the higher range, we have seen people who are, severely disabled because of it, but that's not the norm of people who have this moderate PTSD.
And did you find functional impairment with Amber?
Yes, I did.
Now, Dr. Curry also said that it is not within the scope of a psychologist to evaluate domestic violence. Do you agree with that?
Of course, I don't agree with that. This is what I do for a living, day in, day out, for 25 years. We are specifically trained to understand the profound impact that trauma has on people's lives. That's what we do in the trauma division of the American Psychological Association. We disseminate that knowledge. And domestic violence is one of those profound traumas. Domestic violence is part of state licensing boards, that you can't get licensed in some states unless you take training on domestic violence. You can't renew your license unless you get training on domestic violence. So people who have, specialized training in this area, it is, beholden upon them to accurately assess for intimate partner violence and sexual violence. And it's more important to assess for this sort of scientific understanding of what domestic violence is. So you have to assess for the physical violence, the psychological violence, the surveillance, the economic, the emotional abuse, and the sexual violence. That is not gratuitous. That is understanding.
Narrative.
All right. Next question.
And I want to bring in my guest this hour to discuss that testimony. Sticking with us here is crime analyst Lisa Lockwood, and we also have psychiatrist for women's health, Dr. Yalda Safai, joining us too. Yalda, let's start with you. Do you think Dr. Hughes did well here? She pointed out that in contrast to what Dr. Curry said, those with PTSD can function in society.
Of course. In fact, they function for years before they even recognize they have PTSD, before they even recognize it and seek treatment for it. So it's very much possible for someone to have something called high functioning PTSD. So yes, it's possible.
Lisa, both doctors did not evaluate Amber Heard in the same way. So are different approaches fine? Do you have to nitpick rules and regulations about psychological tests?
Well, I think the guest you have right now would be better equipped to answer that question because she's probably done that. So there are an array of ways of coming up with a diagnosis, and both of them talked about their methods and what they use. Some of them were similar, and then some went beyond the other person's method. But what I do find interesting about PTSD and what we're discovering right now is it's on a scale. Can it be completely debilitating? Are you depressed? Do you have a complete change in your function? Or do you show up courageous, resilient, as Amber Heard's doctor had said? So knowing that there's a scale, I thought that there was a scale with depression, and knowing people in the military and police and people who have had incidents in their life and veterans that suffer through PTSD, a lot of them, I guess, are higher on the scale because they do turn to drugs. They do end up changing their complete function. They're not able to work. And these are the only PTSD victims that I have had to deal with, and knowing that they fit that criteria. So this is new information for me.
And Yalda, so I want to get your take on that because obviously you're the professional here.
Right. So I agree with what she said about there is spectrum for PTSD. You can have mild symptoms and you can have severe debilitating symptoms. And sometimes it's a progressive thing. You might start out with mild symptoms that just become more and more debilitating. And it's only when you have those debilitating symptoms that you seek out help and treatment. Now, in terms of approaches to treating PTSD or diagnosing PTSD, yes, there's a general guideline, but not every single person meets the criteria for PTSD. And it's really, every psychologist and psychiatrist has different ways of exploring this to determine whether someone really has PTSD or not. There's no blood test to say you definitely have PTSD or not. It's very subjective. So people have different methods and different ways to come to the conclusion that a person has PTSD. There is a diagnostic criteria we follow, but every psychologist or psychiatrist has their own way of coming up with an answer.
Now, we can't forget to discuss testimony of psychiatrist Dr. David Spiegel. During cross-examination on the stand, he made reference to the Goldwater rule when asked if he examined Johnny Depp. Let's listen and discuss on the other side.
You were asked about whether you were able to examine Mr. Depp. Do you recall those questions back and forth?
Yes.
And so if I understand your testimony, you asked twice for Mr. Depp to be interviewed by you, correct?
Yes.
Objection leading.
And
Overruled.
And then in addition to that, Ms. Heard requested twice of the court for Mr. Depp to be submitting to an examination of you, correct?
Yes.
And those were denied, correct?
Yes.
And now Mr. Depp is contending that it's unethical for you to provide an opinion in this case because you didn't get an opportunity to interview him. Do you think that makes sense?
Objection, Your Honor.
I'll sustain the objection.
All right. Is that your understanding?
That is my understanding of it.
Okay. Now, when counsel for Mr. Depp was reading to you the Goldwater rule, there were two words that he kind of went over pretty quickly, and I'm going to go over them again with you a little bit slower. And that was that the Goldwater rule was that you cannot make an armchair diagnosis, right?
Objection.
Based on, quote,
Okay.
publicly available records. Do you recall that?
Yes.
Okay. Now, the records that you reviewed in this case were private, were they not?
Yes.
And in fact, Dr. Blaustein's records were marked confidential, correct?
Yes.
And his deposition was marked confidential?
Yes.
Okay. And Dr. Kipper's records were all marked confidential?
Yes.
Objection leading.
And
I'll sustain.
okay, what if any labeling was there on Dr. Kipper's deposition?
All the documents I reviewed were confidential, and I also signed the confidentiality agreement, so everything I looked at was confidential.
Okay, so that in fact does not even comport, that doesn't meet the restrictions that were put.
Objection leading.
I mean, so would it be fair to say that you have not, or have you rendered any opinions in this case as an expert witness based on publicly available records?
I have not rendered any opinion based on any publicly available records.
Dr. Yelda Safai, what could you tell us about the Goldwater rule here? How much weight should the jury take in Dr. Spiegel's testimony?
Very much. It's very unethical and it's very unethical and forbidden for a psychiatrist to pass comments or make a diagnosis without evaluating a patient, specifically if that is a public figure. So I am completely in agreement with the psychiatrist that he avoided answering this because, like he said, the Goldwater rule states that we are not allowed to pass a diagnosis or comment on the mental state of anybody, especially a celebrity, without evaluating them ourselves.
Let's not forget Dr. David Spiegel had quite the circus testimony as well when he took the stand. All right, we're going to take a quick break here on Law and Crime. When we come back, so much more to cover on day 23 of Johnny Depp versus Amber Heard. Stay with us. We'll be right back. Welcome back to For the Record. I'm Michelle Yu, and thanks again for joining us. We are now in day 23 of the Johnny Depp versus Amber Heard defamation trial out in Fairfax County, Virginia, and both sides have rested. As you might recall, the 58-year-old Pirates of the Caribbean star is suing his ex-wife Amber Heard for $50 million. The 35-year-old actress published an op-ed in the Washington Post 2 years after her divorce from Johnny Depp, dubbing herself a domestic abuse victim. Heard is countersuing for $100 million as they both battle it out who caused the other more reputation-related turmoil. Now that court is taking a recess, that gives us time to recap what you might have missed so far. One of the most contentious topics in this trial is the truth of what really happened to Depp's finger in Australia. In Johnny Depp and Amber Heard's rebuttal case, they both called orthopedic surgeons to the stand to try to provide insight on how Depp could have sustained that type of injury. They were also asked which of their stories seemed most consistent with Depp's injury. But first, let's listen to both Depp and Heard's version of the truth.
Mr. Depp, when Dr. Kipper was treating your finger, what did you tell him about how your finger became injured?
I told him that there was obviously, when you saw the damage in the house and everything, the blood everywhere, obviously there was serious damage done. There would be no point in lying to the man. He'd been through it with me and Ms. Heard before. I told him that she had thrown a bottle of vodka and smashed and cut my finger off, the tip of my finger, but a good chunk. I miss it.
Is that your signature?
Yes, it is.
And your signature appears right under the statement, quote, "I declare under penalty of perjury, under the laws of the state of Virginia, that the foregoing is true and correct."
That is correct.
And this is dated April 10th, 2019.
Correct.
Now let's look at paragraph 16, which is on page 5. Specifically line 10. Quote, you write, testify under oath, "While he was smashing the phone, Johnny severely injured his finger, cutting off the top of it," end quote. Did I read that correctly?
Yes, that's correct.
So you testified in this courtroom that after Mr. Depp smashed the phone, he held you down on the countertop by the neck. Do you remember that?
I'm not quite sure of the exact sequence of things, but yes, both of those things happened.
Well, we'll get to the sequence. And this is when Mr. Depp supposedly assaulted you with a bottle, right?
On the countertop, he assaulted me.
So Mr. Depp was able to get you on the counter, right?
He held me down by my neck.
And hold you down by your neck.
That is correct.
And he grabbed a bottle, according to you, while holding you down by the neck, correct?
I'm sorry, can you clarify what you're asking me?
While Mr. Depp is holding you by the neck against the countertop, he grabs a bottle. That's your testimony.
No, those two things didn't happen at the exact same time, no.
While he's holding the bottle, is that your testimony? While holding you down by the neck?
Sorry, what was your question?
So, Dr. Safai, what do you see from their responses in this testimony? Is one more believable than the other?
I can't comment on that because people have different ways of dealing with their trauma and explaining their trauma. A lot of people haven't developed the emotional vocabulary to be able to explain the trauma that they went to very well. So just because someone seems like they're hesitating to explain exactly what happened, or they're even sometimes giving inconsistent information, it doesn't mean that they're outright lying. So people have just different ways of explaining what happened to them.
Lisa, we don't know exactly what happened in this finger story, and we'll likely never know the truth. So how much weight does this Australia incident have on this case? Because everyone still seems to bring it up and we talk about it a lot.
Yes, and Johnny's team was there. So afterward, we had security there, we had doctors there. There was audio recording with Amber crying in the background, and they were talking about what happened, and she was remorseful. So, the words are not matching up with the audio that had taken place in that house soon after, where they were searching for the finger. The nurse was there. So, yes, later on, you can create stories of what happened in defense of yourself. And I've seen that in many criminal cases because they have time to think about what other thing could have happened. What could I say to dispel what's being said against me right now? So how do we prove it? We pull those audios from there. We find out what was said in the aftermath. And we also look at sometimes people protect the person who hurt them. And Johnny, in one text message to somebody, he says, "I cut my finger off." So didn't want Amber to know, didn't want people to know Amber did it, didn't want it in the news. It's really challenging, but we know that it had to take quite a bit of force to do the damage that it did. So I would imagine if we looked at projectiles and we try to recreate certain things, as we often do in criminal cases, where we're looking at projection, bullets, fragments, and that sort of thing, and if we got that deep into that, we'd be able to get a better solution. But obviously, police were not called to that scene, so we will never know.
Each side called an orthopedic surgeon to the stand, though. I want to take the chance now to recap what they both said to try to get a medical explanation on how Johnny Depp's fingertip could have been severed there in Australia.
In your view, what types of mechanisms can cause this sort of injury?
So this is a mechanism of injury that has high velocity or force, generally a crush type injury. A simple fall would not result in a comminuted fracture such as is seen in these x-rays.
And we're using the term comminuted fracture. Can we just define that quickly for us?
So again, comminuted, and it's not particular to a finger, is a medical term for a fracture that has multiple fragments.
In your opinion, could this injury have been sustained in the manner Mr. Depp described?
I do believe so.
And how might that work? How might a thrown vodka bottle produce an injury like this?
So vodka bottle, which is a hard object, would have crushed the tip of the finger, resulting in the comminuted fracture. And in addition, as the vodka bottle broke, the glass would have lacerated the finger, resulting in the soft tissue loss that was also seen with this injury.
What's your assessment of the description of the cause of the injury offered by Ms. Heard?
I think that's highly unlikely.
And why is that?
Because one, in general, when an injury is caused by punching against a wall or a hard object, it is extremely rare to see an injury to the tips of the fingers, which is seen with Mr. Depp's injury. Generally, you're holding something with a fist, and that in general leads to injuries most commonly of the knuckles here, or fractures of the metacarpals. We call these boxer fractures. Second most common after those would be injuries to these, but as you can see, if you're holding something and hitting against something, it is very unlikely that the tips of the fingers will be injured. In addition, just taking into account the radiographs and the pictures of the injury, I would not believe that solely a blunt force against a wall would result in the soft tissue loss.
And with that in mind, let's now take a look at the testimony of the orthopedic surgeon that Heard side called, Dr. Richard Moore, and then discuss with my guests afterwards.
So back to the glass. In the records that you reviewed, Dr. Moore, did you see any adjacent injuries? In other words, injuries to any other part of Mr. Depp's hand other than the tip of his middle finger?
No.
And is that observation consistent with the explosion of glass type phenomenon that Mr. Depp alleges?
Well, I think in the setting of a glass explosion like that, where there's multiple fragments and the tip of the fingers cut off, you would anticipate that there would be other lacerations.
Did you review the documentation in the medical records from the hospital in Australia?
Yes.
Did any of those providers report retrieving glass from the wound?
No.
What about any glass near the site of the injury?
No.
What about any glass in other parts of the hand?
No.
What about any glass in any of the other fingers?
No.
Is there any reference at all, Dr. Moore, that you've seen to any glass in the records that you've reviewed?
No.
And Dr. Moore, in your decades of practice, have you ever seen an injury associated with a glass explosion that was focused on the end of a single finger in the way Mr. Depp describes?
Well, not consistent with the clinical images and the findings in this case, no.
Have you ever seen an injury associated with an alleged glass explosion where no other glass was found on any part of the patient's body or clothing or anything?
No.
So Lisa, as most people are not in the medical field, can we make a true determination of which doctor is correct here? Or do you think people will just lean towards the doctor who they want to believe?
Yes, you're right, because either side is going to be dependent on who's being paid for what side and what they're going to figure out. You would hope that they'd be as honest as possible using their expertise and their skill set. But high velocity makes sense, and that's my language in the police department. High velocity bullets, things that are thrown and projectiles and that sort of thing. What would cause the most amount of damage? So looking at that perspective, I would tend to agree with that. But again, we don't have a crime scene. We don't know how the bottle exploded. Did it explode? Were there multiple pieces? Did it crack in half once it hit the island and hit his finger? And then on the other side, on Amber's side, saying that because they didn't find any shards of glass